Okay. All right. Hi, everyone. I think we're on now. Hello. Welcome, everybody. My name is Omer Kazi, the Director of Policy and Advocacy here at the Authors Guild. Today, we'll be talking about a little known but powerful right that you all have as authors. It's called the statutory right of termination. And it's the right to terminate any grant of rights, any contract that you've signed, provided for in the Copyright Act's Section 203. We're also very grateful here to have Ed Claris to help us break down Section 203, which can be a little complicated and tricky. Ed is the managing partner of Claris Law, CEO of Claris IP, and a professor at Columbia Law School. He was previously Senior Vice President of Intellectual Property Assets and Rights at Condé Nast, General Counsel for The New Yorker, Media Counsel at ABC Inc., and a litigator at Davis Wright Tremaine LLP. So a wealth of experience here. Welcome, Ed.
Thanks for having me, Umair. Thanks for having me, Authors Guild.
Yeah, no, we're very glad to finally be, working with you. I've seen Ed at various conferences and heard his presentations. Always very informative, very, very thought provocative too. So you've and let me just mention that a number of you have already submitted questions to us, and we've incorporated them into the presentation today. If you have logged in, you can send us questions anytime using the Q&A box that's kind of towards the bottom of your screen. If you go down towards the bottom and hover around there, it should say Q&A. Open it up, and you can type your questions in, and we'll address them at the end of our presentation. Okay, also another sort of housekeeping announcement. This webinar is being recorded, and if you signed up using our Zoom link, you will get a link to the archived version, and it'll also be available on our website. Okay, so just gonna start by providing a very basic overview of what Section 203 allows you to do, and then we'll kind of get into its mechanics with Ed. Termination rights under Section 203 are provided. Actually, it's Section 203. Let me backtrack a little bit. Section 203 is the provision that applies to contracts that were made in 1978 and thereafter. Section 203 has a counterpart called Section 304, also in the Copyright Act, which covers contracts that were made prior to that. So we kind of generically refer to it as Section 203 because that's what most authors use now to terminate their rights. And we also call it, as I mentioned, the statutory right of termination. What does this statutory termination right allow you to do? Statutory right of termination allow you to do? As you know, when you write a book, when you're the author, you own the copyright, and when you go to a publisher, you give the publisher one of your exclusive rights in your copyrights, or sometimes parceled out of other exclusive rights too, but primarily the right to print, produce, and sell, make copies of your book and sell them to and distribute them to the public. So I guess that's two exclusive rights. The question that we often get is, when you sign a publishing contract, how long does a publishing contract last? If you sign a mortgage, there's a term, 10 years, 30 years. But publishing contracts have a very vague term, which often says for the life of copyright, for the term of copyright. And that, as many of you know, is life of the author plus 70 years. So that's a very long time. But we also know that publishing contracts can end in a few different ways. And, Ed will kind of run through some of those ways a contract that we think is forever and perpetual can come to an end.
You want me to start?
Yeah, just sort of the slide 3 to go over
Okay. Thank you, Mara, for your introduction. And thank you all for joining today. I'm going to try to take what is a relatively complicated part of the Copyright Act and make it as approachable as possible. And where we're going to start is, two concepts. One is, what does termination mean when it comes to being an author of a book or any other written work? So you'll see here on the column on the left is that authors often have a right to terminate. And on the column on the right, there are reasons why the publishers might have a right to terminate. And these tend to come up in your contract with the author. And the contract typically governs all behavior between the two of you. So if the publisher breaches the contract by failing to pay you, for example, you can terminate as long as you follow the termination procedure set out in the contract. It might be that you have to send them a letter saying you have to cure this within a period of time. They have to get that period of time before you can then terminate if they don't satisfy their obligations. The concept of a book being out of print is something that has historically been in book contracts. This is a really important clause for anybody to think about, because in this day and age where there's print on demand, books can pretty much always be considered in print and available for sale. So the contract itself has to take into account what that means. And then the publisher goes bankrupt. That is a situation that is oftentimes delineated in the contract. And if it is, then you'd be able to terminate if the publisher goes bankrupt. And then the last one, there's insufficient sales of the book. So this kind of goes together with the book is out of print. When you're doing your contract, you tend to want to say, instead of it being just has a single copy been sold in the last year, you might want to say you have to sell 300 copies in a given year. And if you haven't, then it's considered to be insufficiently sold or out of print. And therefore you may be able to terminate. Whether the publisher allows you to include a clause like that really has to do with your leverage, how badly they want to publish your book. And so to be determined, and also oftentimes it's the person who's negotiating on your behalf. It's an agent or a lawyer who has historically gotten those kinds of provisions in the contract. Publishers will many times follow that agent or author's previously existing precedent. Depends on who you're dealing with. And publishers can also terminate if you breach, if you fail to deliver the work, and also sometimes if there are insufficient sales. And if the book is out of print, of course. Or it depends on what the contract actually says. So those are contractual termination rights. They pretty much exist all the time, and you'll find them in your contract. What we're talking about here is what is not in your contract. The stuff that applies termination right on you, for you as a human being, to take back exclusive perpetual rights that you've given to a publisher that you've promised never to terminate. You promised that they might be perpetual. Even if you said all those things, still there's a termination right. And that's what we're going to talk about, because it's really important that you get a chance to have a second bite at the apple. And why is it that you get a second bite? Why is it that Congress gave you the ability to terminate a grant that unequivocally provides for a perpetual right in the publisher, or even that gives the publisher all right, title, and interest into your copyright? Why? Because Congress decided when they passed the current 1976 Copyright Act that authors should be taken care of. They should be watched out for, because they tend to be less influential or have less leverage than their big publishing counterpart. And so, as you'll see here from the legislative history of the Act in 1976, It says a provision of this sort is needed because of the unequal bargaining position of authors, resulting in part from the impossibility of determining a work's value until it has been exploited. Well, it's fantastic that they did this, because the truth is you really just don't know how many books you're going to sell, or whether your publisher is really going to come through for you, or whether if you become a much more famous person, you might really want to have the ability to take back rights and then enter into a new agreement with the same publisher or with a different publisher on better terms. So what we're going to talk about is exactly how you do that and exactly who can do that in the process. And we're going to try to get done in about 25 minutes so that you have time for your questions. And we run this no longer than an hour, hopefully even a little less, so that everybody can get back to their days. Okay, so when does Section 203 apply? So again, what I'm doing is I'm going to go through basically the Copyright Act. If you were to open the Copyright Act or look on Google, what does Section 203 say, you'll find a lot of what I'm going to talk about. So what I'm going to do is both talk about what the statute says and also go through some hypotheticals and some real life scenarios so that you can see how the statute applies. All right, so Section 203 applies to grants of transfers or licenses that were made, both by the author of a copyrighted work on or before January 1st, 1978, like Lamar said, or while you were alive. And while you were alive. So what that means is that a transfer is I'm transferring you all right, title, and interest into my copyright. It's an actual transfer of the copyright itself. And then the licenses is a license. So usually with publisher, you grant an exclusive license for the publisher to exclusively publish your book. There's also such thing as non-exclusive licenses where many people are publishing. Each of those can be terminated no matter what the language of the contract says. So when it says Section 203 applies, even if there was an agreement to the contrary, that means that the contrary agreement would be one where I'm saying forever and ever and ever, I grant you all these rights. That's an agreement to the contrary. And even though it's there, you may terminate. Section 203 does not apply to works made for hire, which I'll explain, to grants made by will or bequest, which I'll explain, and to pre-1978 grants or transfers, grants of transfers or licenses, because Section 304 would apply there, just like Lamar said. So I won't explain that one further. Works made for hire. A work made for hire is a work that is different than a grant of all right, title, and interest in copyright. Why? Because a work made for hire is the kind of thing that happens when a company is working. So a company can't really make anything. A company relies on people to make things. So those people are either working on contract or are employees. And so the work for hire doctrine says that an employee, a person who is getting a W-2, who produces a work for his or her employer, is doing it at their behest, and therefore the employer is the author of the work. You, as the worker, are not the author. You might be the scribe, but you're not the author. No matter how much creativity you put into it, no matter how original your work was, if you are an employee, your work is automatic and you're working within the scope of your employment, a concept to be defined very carefully. Everything you produce while you're an employee of that employer is a work for hire. And therefore the employer is the author and the copyright owner. And if you are not an employee, but you are under contract with the employer, then you have to have a contract that says that everything you do and everything you produce is work for hire to the employer. It actually has to say those words, work for hire. The statute says that if the words work for hire aren't in the contract, then it's not a work for hire. Also, you have to enter into that contract before you start writing your book. you can't come to the publisher with a finished book, and the publisher can't say, well, let's make this a work for hire and call it a work for hire. The work has to not have been done yet for you to have a work for hire arrangement. So the truth is, even though work for hire is the sort of situation where you will never be able to terminate your rights, and therefore don't even think about it, it doesn't really happen very much in the book publishing industry. So if all of you who are watching or listening are book authors, as a general rule, book publishers do not commission works on a work for hire basis. As a general rule, they take exclusive rights to your work, and at the very most, a grant of all right, title, and interest. But even in that case, not very often. As you all know, they're usually very broad exclusive right licenses, which can be terminated. Mm-hmm. A grant by will or bequest is one that you grant in your will to somebody else. And that grant cannot be terminated. So if you give a book and its copyright to one of your nieces and nephews, a very disgruntled spouse or a very disgruntled child who inherits everything else in your estate cannot somehow terminate that right because they don't like that niece or nephew. Okay, let's keep going. What timing? How long do you have to wait to terminate? Termination of the transfer or license can be made within a 5-year window beginning at the end of 35 years from the date of the original grant of rights. Therefore, you can wait 30 years. Sorry. You can, during the 35, after 35 years, you have this window where you can terminate.
At the end of 35 years, so.
I'm sorry?
The termination period begins at the end of 35 years. So yeah,
right. Right, so it's actually the beginning of the 36th year. Yeah. That's exactly right. So if you look at the 78 Copyright Act, you'd have to count if your license or grant was entered on the date that it happened, you'd have to wait 36 years before, and that would be your window. However, the original transfer includes the right of publication of the work. The termination begins at the earlier of 35 years following the date of the work's publication or 40 years following the date of the original grant of rights. That provision was put in there because the Copyright Office or the statute worried that you might give rights to a publisher and they may never publish it. And therefore, or it may take them a really long time to publish it. So they didn't want to leave that period of time to be longer than what they really wanted. They wanted it to be in this 35 to 40 range period, and that's why there's this distinction. Okay, so we get to our first hypothetical based on what we've gone through so far. This is like a test. So in order to do our test, we're going to have Umar
read the. I will ask you the hypothetical, and then we'll go get back to law.
And then I'm gonna freak out with the answer. Okay, let's give it a shot.
I'll try my best law professor voice. So Jane, a struggling author, finally lands a book deal with Exploit Books EB for a novel, The Triumphant Wordsmith. EB offers a royalty rate that is below industry standard, but Jane is overjoyed, as many authors are, whenever they get a contract. On January 1st, 2019, she signs a contract granting EB the exclusive right to publish the book in English and all other languages. The Triumphant Wordsmith is published on January 1st, 2020. It becomes a bestseller and an instant classic. 1A. When Jane realizes the true value of her work, she's despondent. After all, she granted EB the right to publish her book in perpetuity and explicitly agreed that she could not terminate the contract for any reason. Will Jane ever be able to terminate the contract? If so, when?
Okay, that's a good first question. Well done. Let's see. So yes, Jane can terminate her contract. Why? Because she can utilize Section 203 of the Copyright Act. She has to do everything right, which we'll talk about later. But for now, the answer is yes, she can terminate it. And when can she terminate it? Well, that is 35 years following the date of the publication or 40 years from the grant. So she'd probably be able to terminate on January 1st, 2055. That would be when, and she would, then we're going to talk about more, because termination is not something that Jane's going to really ultimately want. She's going to want to terminate and have a new contract that has better terms. And so that's going to be a key component of this whole thing.
Great. So when is the earliest date Jane would be able to terminate EB if the Triumphant Wordsmith was not actually published until January 1st, 2025? So.
Well, then you'd have to look at the 40-year schedule, and it would be January 1st, 2059, because that's the 40 years after the 40 years.
And suppose for a moment that Jane has been commissioned by EB to write the Triumphant Wordsmith as a ghostwriter for a politician, and that she signed a contract stating that any content she produced would be a work for hire. Would Jane be able to terminate EB's rights under Section 203?
What do you guys think? We did it. It was the work for hire doctrine, and the answer is no, because the magic words work for hire were in the contract, and therefore, and she signed it before she started to produce work, therefore it was a work for hire and she could not terminate her rights. Okay, great. Thank you, Lamar. That was good questions. So let's move on to, why is my thing not moving on? Oh, let me see if this works. Okay, so let's move on to the question of who can terminate. So termination of transfer or license may be made by, okay, if the grant was made by a single author, the author of the work. If the author is deceased, the statutory successors or who own or are entitled to exercise the majority of the author's termination interest. Really important to, though, we're going to look at what author types can terminate. So first we're going to look at what there are multiple authors, because sometimes you all might have a co-author who's actually writing the book with you, or you might be the writer and you might have an illustrator who's also producing copyrighted work, the illustrations. And so the question is, what percentage of all the authors are needed in order to terminate interests? This gets pretty tricky. And if you do have a multiple author situation, I would not go about this on your own. I would seek out Umair's professional insights, or some other lawyer, or the Authors Guild, or me, or whomever you'd like. But in case, I'll go through it though. In the case of a transfer or license granted by 2 or more authors of a joint work, the termination may be exercised by a majority of the granting authors, so majority being 51% of the interest. If any of the granting authors is dead, that author's statutory successors who own and are entitled to exercise the majority of that author's termination interest. And if the author separately granted their copyright rights, they may unilaterally terminate that grant without being required to have a majority of the joint authors join them in the termination. Now, this third point is not in has not been found to be in every jurisdiction, but it is definitely a thread of the case law that does permit a joint author who has a separate contract. So say you have 2 writers of your book and each of you have your own separate contract. The prevailing law is that if one of you terminates, that grant is terminated, even if the other one does not. If you are in the single contract, the outcome is different. You have to have a majority of the interest terminating. So hypothetical number 2. There.
Hypothetical ad, you ready? Okay. On January 1st, 2030, Exploit Books enters into an agreement granting editions exploitusis, the right to publish French versions. I've been trying to learn French and I'm apparently not very good. The right to publish French versions of Jane's critically acclaimed bestseller, The Triumphant Wordsmith in France. Would EB be able to terminate this agreement under Section 203? Would Jane? So.
Okay. So this raises the very important distinction between human beings and corporations.
Mm-hmm.
So corporations cannot terminate rights. They don't have the same paternalistic support that the Copyright Act gave to human beings. Mm-hmm. The Congress was interested in helping people, not companies, and therefore only human beings can terminate.
For once.
Right, it's true. So, and that goes for the case where, you know, just in any situation, no right of termination if you are a corporation, even if like the bequest was to a corporation or anything of that sort. Second question.
So would, but the second part of this question, but Jane.
Oh, yes. So she would not be able to terminate either, because this is in France. And since in France, French copyright law would apply, not US, then the US Copyright Act wouldn't apply.
And it also ties into the derivative works thing that we're going to touch on later on, right? Because the translation, it's accepted from the 203 grant anyway, because it's a.
That's right.
Yeah.
That's exactly right.
Okay. So the second question, let's assume Jane wrote The Triumphant Wordsmith with two co-authors, John and Jim, both of whom also signed a contract with EB. As the statutory termination window approaches, Jane is anxious to terminate the agreement so she can pursue other licensing opportunities. However, John adamantly refuses to terminate the agreement. Jim has died and left 1/3 of his estate, including the collective rights of all of his writings, to each of his 3 daughters. How should Jane proceed? This is a hard one.
This is going to be a real law school question.
Right.
I imagine the people who are listening are feeling like, oh boy, this is getting too complicated.
Yeah.
I went through this one, but I think we may have to skip some other.
Yeah, let's skip. This is a little too esoteric. I think there's some more important things that we can cover. Okay.
But bottom line, you need to have majority interests, and you need to look for majority interest before you can terminate.
Mm-hmm.
A little complicated, but let's keep going. You can ask questions later if you'd like.
Yeah.
So how do you terminate? Authors or their successors must serve a notice of termination on the grantee or the grantee's successor that complies with the specific requirements of Section 203. And there are a bunch of them. I'm not going to go through all of the requirements that it takes, but you have to name the work, you have to say when it was published, you have to say who is the authors. There's a bunch of things, so I recommend to you to look at the statute or have somebody do so.
We have a guide. We also have a termination guide. So if you're in the process of that, you can, and a member, you can reach out to us and we'll share that. We have a template letter for that includes all of those statutory categories.
Wonderful. That's a great point. Thank you, Amir. And so important to note though that the letter has to be issued at least 2 years, but no more than 10 years before the effective date of termination. So you can't just like issue it right now and say in 35 years, if it's more than 10 years away, I want to terminate. You have to keep track of your timing. And the letter itself has to be recorded in the Copyright Office before the effective date of termination. Really important. Both of those are killers if you don't satisfy them. So make sure you remember those. The other things are also pretty technical and very important, but these are really key.
Yeah.
I'm going to keep going, but I'm going to try to move relatively quickly because we want to make sure to get to enough questions.
Yeah, I think we can skip the next hypothetical and just sort of like cover the slides. What do you think?
Sure. Okay, so reversion of terminated rights. On the effective date of termination, all copyrights covered by the terminated transfer or license revert to the author or authors or their successors, including any owners who did not sign the notice of termination. Important. So if only one person signed the notice of termination, but there are 2 authors, it returns back to all of them. Section 203 prohibits authors from making further grants of the right to third parties until the effective date of termination. That's a really important one because what it does is it gives, so it has to be no more than 10 years and no less than 2 years from the effective date of termination. What that does is it gives at least 2 years of an exclusive negotiation period to your publisher. Your publisher will have received your letter and they'll have at least 2 years to come to you and say, okay, we understand that you want to terminate. We understand that your book did way better than we thought, or we understand we haven't done a very good job and we want to do better. We will give you a whole new contract with all these better terms and treat you so much better in the next 35 years. Please sign. And so they have the right to have that exclusive period. And then authors can make further grants to the original grantee. So that's what we just said. You can make a further grant to the original grantee during that notice period. So it's only them exclusively. Great. Keep going. So we're going to skip this hypothetical, but it'll be on your recording, so you'll be able to look at it if you'd like and send questions later if you'd like.
Yeah, you can send questions. We'll go over that.
So does termination affect derivative works? Yes, it does. And this is a very important part of the right. So if you can imagine, you will have transferred all right, title, and interest into your book to a third party or a publisher. And those rights include the right to make a movie. And so during since you've granted them all right, title, and interest, they turn around and sell to a big movie studio the right to make a movie on your book. And they were totally able to do so. So if after the fact you terminate the publisher's right to continue to publish the book after the termination period, then what happens to that movie that's out there? Well, the movie stands separately. It was authorized to have been made during the time that the publisher had the rights, and therefore you cannot, by terminating the rights of the publisher, you cannot affect the movie rights that the studio acquired because they got them legitimately. So it's not terminable. So that's really the way it works. Now, what happens is you then step into the shoes of the publisher and you may be able to get the income that the publisher would have otherwise been able to get during the term that they had, but you can't terminate the rights. Okay? There are some more complexities.
That we talked about, a translation as a derivative word, that the previous hypothetical. Yeah.
Right, right. Okay, this hypothetical we're going to skip because it gets into the derivative works and the film adaptations, and I think there'll be questions. So let's just go to that.
Okay, so I'll pass that far, and still have time to send in questions. We're doing pretty good on time. Thanks, Ed. So Karen asks, I'm dealing with a new edition of a 1989 book. My co-author's contract was first signed in August 1987 with Paragon Books, but the current publisher is Da Capo. Is the 35 years determined based on the original publishing contract?
It's based on your original contract plus, but if you have a contract that succeeded it, you'd have to look at the most recently signed contract. In other words, if there was an amendment or a change in any way, then it's the date when you last signed the contract. But the fact that the first publisher, Paragon,
I'm assuming it was acquired, yeah, or assigned the contract to Da Capo, yeah.
Right. So if the publisher Paragon assigned its rights to Da Capo received, I would assume they received all the rights and obligations under the contract, and therefore they would be subject to the same exact termination rights that you would have had against Paragon.
Great. Okay, second question. I have paper books, no digital copies. The publisher is not selling them. I want my rights back, but there's no out of print clause in my contract. Do I have any rights I'm sure they don't want the book. They're also large and indifferent and occasionally hostile. So I mean, you have the Section 203 right, and if they're not selling a book, it could possibly be a breach of contract. You know, you could argue bad faith. There's different ways you can get your rights back. The Authors Guild does help members in these situations. So if you are a member, you can send in a query with more information about that, and we'll see if we can help you out on that.
Right. The Authors Guild would actually be great in that situation also, because if the publisher really doesn't care, then they may want to do you a solid and give you back your rights, and the Authors Guild may be able to help you get them.
Yeah. A lot of times we mediate that, and publishers do often give up rights if they're not interested in the book, even though there's no out-of-print clause in the contract. Okay, so do these termination rights also apply to articles and essays in magazines and newspapers?
The answer is yes. In fact, these termination rights apply to all media, whether it's written, it's photography, it's illustrations, it's videos, it's music. All types of work that are covered by copyright are subject to the termination right.
As long as they're not made for hire. And so if you're a newspaper, if you're a staff reporter at a newspaper and you're writing articles as a part of your employment, that's a work for hire. So in that case, you wouldn't be able to terminate it. Or if you're an independent contractor, freelance writer who writes an article as a work for hire, then you wouldn't be able to terminate it. But otherwise, yes. Does 203 apply to stage plays as well? I had a play option in 1980, which included a work for hire to write a mini series based on the play. The miniseries script was written and delivered, but is still unproduced. The miniseries script was not the same format or structured as the play, but was based on the same historical figure. It remains unproduced. Is it still possible to get the rights to the play back utilizing Section 203?
That's a great question. It's like almost another law school question.
Yeah, there's a derivative. Yeah.
Right. So the stage play, it sounds like you wrote and was not a work for hire. It was really the script for the miniseries that was a work for hire. So if the stage play was not a work for hire and it was just a grant of rights, then you could get back those rights for sure. And the fact that you produced the miniseries for a fee, the script, you may not be able to get that back. You probably can't, but it doesn't sound like it matters because nothing was produced during the term. No, this was 1980. So yeah, you're in the window. You may be a little late. So 20, 30, 39, you are a little late.
2020, yeah, because you would have to submit the termination notice 2 years before the 2020 expiration, right? Yeah. So you just missed the window.
Yeah. Very important to keep track of these things.
But option contracts often have, I mean, they shouldn't be perpetual. That's an option contract. You have to produce something within a given period, or you lose the option. So
that's true too.
Yeah. Okay. So next question. The original author has to be alive 3 years from now. I am co-authoring the new book because he is 86 and has a poor memory. So he's given me full authority to rewrite for a new edition. We are waiting to hear from Da Capo, who are quite interested, but I start to wonder if waiting might make sense so we could renegotiate from scratch or go to another company. So if I'm understanding, you're saying instead of writing a new edition for Da Capo, does it make more sense to wait and terminate under Section 203?
I don't really have an answer for you. I think that this is a strategy that you should probably think through.
Yeah, definitely. I mean, if you think you can get a better deal, use that right and republish it. But yeah, it's a good question. Will you also include text shown on the screen? Yes, we will make available the PowerPoint.
Yes, the whole thing.
Are you talking about contracts with the big 5 publishers? Because I would never sign a contract that long. And who cares if you
Who cares if you can terminate after 40 years? Well, if you're 40 years is a long time, but the life of copyright is a lot longer. So
yeah.
People care about the remaining years because it's quite a number of them, and
Absolutely.
the work is valuable. And if you're talking about a big five publisher, pretty much every publishing contract I work with, small, medium, and large, they almost all seek perpetual exclusive publishing rights. So I don't remember many that would get a very short-term right.
Yeah. I barely ever see any short-term ones. I mean, 90% of them are perpetual. This is an interesting question. Can the U.S. government terminate an author's copyright, as in a bankruptcy? Could a trustee come in and invalidate a contract?
It is a very complicated question that varies based on the circuit, federal circuit, and if you have creditors that are seeking to get the access to your royalties and you're in bankruptcy, you need to look and specifically hire an attorney to help you with that question. And
a bankruptcy attorney,
circuit by circuit.
Yeah, very technical, because bankruptcy law often trumps this.
But the IP value in bankruptcy is something that has come up quite a lot. Because you've got publishing houses and stuff to go bankrupt.
We did some work on like the executory contract, and it's so. We'll talk about it some other time. What if you have the same book published by one publisher in '93 and then republished by a second publisher in 2009? What year could you request your rights back republished?
It's the first date of the publication, unless you entered into a new contract.
Exactly.
If you entered a new contract, then that new contract is the one that is governed.
Exactly. Yep. Okay. If I can't inherit the right to terminate, although my uncle leaves me his copyrights in his will, who are the successors who are allowed to terminate under Section 203? Why isn't an heir a successor? Am I missing something? So this is a good question. Difference between grant under a will and getting copyright through a descent.
Yeah, I think you're absolutely right, Umair. Like, I think that may be something I didn't make clear. If you receive a copyright by will, by the will document, you are the copyright owner, and you inherit the right to terminate. If there is no will and the copyright escheats to the heirs, then you follow the state statutory escheatment laws. So I think if you did inherit the copyright, if I understand your question correctly, I can't see your question at this point, then you should probably be able to terminate. Right. Do you agree with me, Umair?
Yeah, I agree with you. I think it's interesting because I think it does refer to statutory heirs. So I'm not sure, if an assignment by will to someone that is not a blood heir works the same way. We might have to look, because there's statutory heirs that are contemplated in the statute, like your next of kin. But then I could assign, my copyrights to the Authors Guild, for instance. A lot of people assign copyrights to us in their wills, and we're an organization, so we don't have the right of termination in any case. But for instance, if we were one person, would we also get the right to terminate through a will, even though we're not like a natural heir? It's one of those. It could be one of those questions that has, that's a gray area in the law. I mean, we'll definitely look into this, but yeah, I think Ed successors are, if your uncle, assigned it, you very likely got the inheritance. Sorry, the termination right. But good question. Okay, I will be submitting a termination letter for my fantasy novel for children. I understand this only applies to my U.S. rights. However, I wish to cease publishing with the hardback publisher, but want to continue to publish with the paperback publisher who have sold most of the books. Should I, or do I have to terminate the paperback publisher at the same time so I can renegotiate that deal?
Is it the same publisher? So let's say you're dealing with one of the big five publishing houses, and that same publisher acquired the right to publish your book in hardcover and in softcover, and it may be a different imprint under the same publishing house. So an imprint, a softcover imprint versus a hardcover imprint. From what I understand, you have to terminate the contract, not specific rights inside the contract, so it has to all be terminated. But if these are two separate contracts, one for hardback, one for soft, then you could terminate one and not the other.
Very true. That's excellent. That's okay. Any way to enlarge the 5-year window? Lobby Congress.
Yeah, I don't think that this is a really technical statute and there's nothing to do to enlarge. I mean, I don't even think that you can get the publisher to agree, but you might be able to. I've never looked that question up, whether you can get a contractual extension from the publisher. I don't know why they would give you that, an extension, what's in it for them, but.
Yeah. Does Section 203 apply to stage plays? Yes, it does. Just to be clear, there's no way to use Section 203 to terminate, even if sales are essentially zero, if it has not been 35 years since the contract. Correct.
Yeah, you cannot use 203 in any way other than what we just described.
Yeah.
The zero sales is a contractual question, not a statutory question.
Yeah. So we have already answered this question, but I'll just read it. I authored a book in '87 and revised it in 2005. Can I use the '87 date? You
Yes,
can, because the same contract.
You can, as long as it's the same contract, correct.
Okay, cool. Can a publisher sign new sublicense after notice has been served, even if that's sublicense to an associated company? After notice has been served.
That's a great question. The answer is yes. Can a publisher, so let's say you have between 10 and 2 years before the window, the termination window to serve notice of termination. So you've got to, let's say you give the publisher 2 years to have this exclusive period. During that 2 years, the publisher can go ahead and do whatever they want. So they can sign new sub-licenses, they can sign rights to create derivative works. That's the one reason why you probably don't want to do it in 10 years before, because you don't want to give them so much notice to do all sorts of things with your work during that period when they know they're going to lose their rights. You probably want to be closer to the 2 years without being too close to be worried that you'll miss the deadline. But yes, they can issue sub-licenses during that period.
Similar to the questions we've already answered, contract signed for print rights in '97, additional rights for the same book sold in 2006 for digital. Does the 35-year countdown start from '97 or from 2006? If the digital rights were sold in a separate contract, it's 2006 is the start date, '97 for the print rights. And does the termination window run for years from signature of the contract / publication, or years from 31st December of the year of signature publication? Okay, so does the 36th, the beginning of the 36th year, is that from the date of the contract or the beginning of that calendar year?
The calendar year has nothing to do with this. It's the date of the contract. Yeah.
Okay. How can I get a hold of termination template mentioned by Omer? You can send us an email, Linda, staff@authorsguild.org, or you can send me an email at ukzi@authorsguild.org. Okay, so we have time for just a few more questions because we're approaching the end of the hour. I published a novel in '84 with a mid-sized publisher that has since been acquired by my current publisher. I doubt that anyone's interested in the book, which has not really sold for years. I haven't gotten a royalty statement for a long time, and it's available only from third-party sellers on Amazon, and I retain 100% of film rights in the original contract. However, one never knows. Do you think I should bother to terminate the rights? Yeah, I mean, I think it's good to have your copyrights back. I mean, there may be other ways this contract's already you could make the argument that they're in breach of contract because they haven't paid you royalties in so long, etc. But we definitely, as the Authors Guild, is a big proponent of recapturing your rights, because you never know what kind of second life awaits your book. Okay, can we pay Ed? Can we pay Ed for a contract review and legal opinion? If so, how do we contact him?
You can contact me at my law firm, Claris Law, edward.claris@clarislaw.com.
Just quickly on that, Ed, in terms of what kind of services do you provide for authors besides contract reviews, negotiation? Do you do litigation for authors, disputes?
I do. I help them, and I also do vetting work. So I will review a book for libel, privacy, copyright concerns, and I help with certain types of investigative reporting. So if you want to do some like wiretapping, or just like on the phone recordings, or you're having difficulty reaching somebody and you want to show up at their door late at night, or any number of other things that might raise some concerns, I help authors with that stuff all the time. I've been doing this kind of author-publisher work for about 27 years.
It's a very sensitive area, especially for investigative reporters. The threat of all sorts of lawsuits that they can't, defend really becomes a free speech issue.
I actually do help authors sometimes get insurance if need be. So they sometimes need an opinion letter from a lawyer.
That's very helpful to know, and yeah, that's okay. So yeah, we'll connect on that. Okay, after the lawsuit against Harlequin was settled, I signed the amendment that was offered for higher royalties. Are you saying that by doing so, I gave up my right to use Section 203 for all my earlier contracts and have reset all those books to the date of that amendment?
That is correct. You have reset your date to the amendment. If in fact the amendment took into account all those prior deals.
Yeah, it likely supersedes everything that you have signed.
Yeah. You had a second bite. You already gotten a second bite of the apple.
Yeah. I'll read this compliment, Ed, also, because it's always nice to get a compliment. Not a question, just amazed at the high level of value you delivered today. This is very comprehensive and high utility stuff, guys. Very grateful to have an esteemed guest online.
Thank you very much.
Thank you very much. Okay, so another e-rights question. Again, it's contract by contract. If the work was agented, does that have any relevance? That is the agent's perpetual right to receive commission from the exploitation of that work.
Oh, good question. So the question is, can you terminate a contract with your agent? I think that's the question. And if that is the question, the answer is yes, you can. You can terminate your your contract with your agent. I've never had to do that, but I think
I'm just thinking around this question, if there's been ever been any lawsuit where the agent sues the author for exercising the termination right, because the agent's right is also embedded into that grant of rights to the publisher.
Very good point. No, but I think that they lose. I mean, once that contract is terminated, all of the obligations under the contract go away with it.
That's what I'm guessing. But agents sometimes have this agency with an interest, et cetera. So someone, another thank you, Ed. I think this is a good place to end. We don't have any more questions.
Yeah.
Ed, do you have any other words of wisdom, anything about your firm, anything about the work that you've done that you would like to share with the participants?
No, I think, I am honored to be on this webinar. I'm honored to be asked by an organization that I respect immensely, the Authors Guild. I'm really glad that you all attended. I've done webinars where nobody asks questions. This is clearly not that audience. I really love questions, and be in touch if I can be of help. My firm is clarislaw.com.
And we'll circulate materials related to this webinar that will have also Ed's contact information and information about, you know, getting termination templates from us. Thank you again, Ed, and hopefully we'll be able to collaborate soon on another, you know, wonderful publishing law issue.
Yeah, I love that. Thank you.
Have a great afternoon.
Take care. Bye-bye.
Bye-bye.